there was a corruption. Corruption has a certain extra amount of element,
Yes.
which is different from the mere illegalities and irregularities.
Yes. Yes.
So that may have been a ground.
True.
We expected that that may have been a ground, but in the judgment,
That is.
why does he lordship go to that effect? This predisposition which was being urged by Mr. Dotto on the first day. Now, from the judgment, paragraph 17 to 22, his lordship proceeds on the basis that I need not go into the judgments.
Yes.
They are poor persons, they are jobless.
Yes.
So I take up the role.
Yes.
And I ascertain that yes, there was a.
Yes.
So is there any judgment to that effect that these are the described parameters on which 165 could have been applied?
I have
No
not found.
argument.
I have, in fact, I have asked all my juniors, because this is.
So no, then what is your answer to that? But according to you,
My
but according to
yes.
you, why will a constitutional court
Should.
is going to that point? Why?
There are, if I would say, allow me to say this, law and justice is a living thing which grows. So as a part of the institution, most likely I will not, I'm saying very subjectively here, I will not make any attempt which goes contrary to this living nature of law and justice. Meaning thereby, what was Article 21 50 years before and what is Article 21 today, there has been a change. For an example, there was a time the conception had been that as if Constitution is providing these rights. But the change is that no, by natural law as a Homo sapiens, there are certain things which cannot be alienated from you. Constitution is only recognizing. It's not a source of birth of your rights. For an example, someone is thinking. That is not that Constitution is giving. So it is constantly, my lord, changing. Keeping in mind the change and the living nature, I would say that today, in the present context, I don't think we have arisen at a stage where lordship are required to frame up parameters that under these circumstances 165 can be utilized.
Yes. All right.
My lord, then if I can just add two more sentences on that, what I feel is, if the perception gets changed, for an example, if the context becomes clear in a proper perspective, that actually it was in a para teacher, which is a separate category, then, my lord, anybody, even the learned judge, would have thought otherwise. So maybe the perception, connecting all these perceptions, starting from the aptitude assessment vis-a-vis a separate test and this marking, all connected, one may have a perception that there is a corruption. But when lordships today is seeing it in a different perspective with all the facts and figures before your lordships, there may not be any requirement at all to frame up parameters for that. If lordship finds that this is a case where if there are necessity, no doubt, but my respectful submission that possibly this is not such case. This is not such case where the lordship would be requiring to frame up parameters under which there is a requirement of the High Court to enter into 165.
Mr. Dhar, there is nobody has addressed us on the issue that suppose the state 2014, state 2012 primary teacher appointment, you find a nagging indication to the effect that there has been transference of money, there had been a money trail, there had been a scam, there had been arrests, but nobody of you have argued this. that where does that link us? Suppose in education, in education, suppose there are 5 consecutive investigations going on.
Correct.
One upper primary, one primary,
Correct.
one lower primary, whatever it is.
Correct.
So, as constitutional court is looking into the matter in the backdrop of the corrupt procedures which has seeped inside our education system.
Correct.
But nobody has argued us that suppose you conduct an examination.
Yes.
My brother and myself are participants in that.
Yes.
You realize after the examination that there were 1 lakh candidates and there was a large scale corruption or scam, whatever you describe.
True.
But if I am there, you have to link me with that corruption. Then the analogy comes of the illegal beneficiaries or the persons who have illegally, suppose a person has given a certain amount of money to certain person, and on the backdrop of that he has got the appointment. But it is, how do you establish it?
May I say this?
One is that there is direct evidence linking me to that offense.
Yes.
That yes, I have given bribe.
Yes.
And the another is the perspective which you are arguing.
Yes.
You have repeatedly said that don't apply the perception to the perspective.
Correct.
But what more can be done? The perspective is all round corruption and scam. Then, as a responsible citizen, how do you argue?
May I argue?
My lord, kindly do not drag me into that illegality because there is no evidence connected.
I understand. May I say? I have understood.
So this is the soul of the court.
Yes.
Constitutional court
True.
is seeing that 5 stages where corruption is there.
True.
Investigation is going on. CBI, CID has come into the picture.
True. May I?
How do you, suppose you were in the seat of a judge?
Yes. How I would be responding?
That's your perception. That's your perception.
Has to
The
be.
division court may not apply that perception because we are independent human beings.
Correct.
What is wrong to you may not be wrong to me.
Absolutely.
But you cannot just cull yourself out from the regards of this perception which has led to the delivery of this judgment.
Well, may I say this? I have understood. Now, this part of the submission is not as a counsel.
But
It
nobody has argued before us.
No,
Still,
no.
this is the
Well, I have
7th
understood.
hearing.
I have understood.
Nobody has argued.
I'm
Nobody has argued that there is not a scrap of paper to establish that I had given bribe to obtain the appointment.
May I say this? May I say this? Well, this part of the argument submission has got nothing to do with appearing as a.
No, that is only. No, Mr. Bandyopadhyay. It has been argued what? That Mr. Datta has proceeded on the definition of corruption. Then what is corruption?
On facts and figures, like today.
Just hypothetically imagine a situation. No. Why we have said hypothetically, you imagine a situation. Today, an investigation is going on. Tomorrow, say the investigation attains finality, and it is found that the person who have taken there is direct evidence and they are guilty of this thing.
May I?
Despite the institution having no legal right, and court will not examine because this is the lead court, not as a PIL.
Court has. It is not a. You are going into.
No.
You are not independently viewing the matter. The answer which we are wanting.
এই জায়গাটাই বলতে চাইছিলাম যে একটা ছোট্ট একটা লাইনে বলছিলাম
May I?
That we have.
I have. This part has got nothing to do with my clients. Me as a counsel, I'm saying, because whatever I think. Well, I'm continuing where Lordship ended. In the entire environment, when the entire environment is polluted, what to do? That's precisely. We have now the perspective of 26,000 gone. I'm saying the
No, we are
SSC
not
case.
concerned. We
I'm
are-
saying the other. So the environment. So far as this case is concerned, there is a reference of the word CBI investigation. Lordships are aware that every recruitment processes are separate. Like I have to pass state. Assume I have passed state in 2014. Does not mean I will only participate in 2014 or 15 recruitment. Once I am TET passed, it's a prerequisite. Then I can participate in
That
any.
Mr. Kollan
Yes,
Bandyopadhyay,
Mr. Bandyopadhyay has said that. So what I'm trying to say, in the end,
stepping stone.
in the end,
They apply that TET not only for this, the training qualification will remain with the TET eligibility criteria. It
yes,
specifies 15 marks in a selection process, as in this case.
yes. No, what I'm saying is that so far as any allegations of the TET, Lordship will not find anything, any paragraph being dedicated anywhere in the judgment, not in the writ petitions, nowhere. Today, before your Lordship, I could have understood, but there are situations where Lordships have to enter into. And there are situations where Lordships are not required to enter into. In my humble understanding, Lordships are not required into the environment aspect of, as Lordship was expressing, I'm saying metaphorically, based on the writ petitions, affidavits, pleadings. This is a case.
You leave it untouched.
Yes. Why? Why? Well, I say why. There is a reason for that. Why? Reason being, in the entire writ petition, Lordship will not find enough materials.
Yes, that you have, that has
And-
been shown to us.
And only tilting factor, I could have understood that Lordship feels that every part of the evidence, every part of the marking, whatever learned single judge has said, that is correct. But there is a likelihood that Lordship may feel that that was a perception of the Honorable Single Judge. Huge, as I said. The marking taking from the para teacher. So therefore, if Lordship picks up 4 or 5 points of the entire judgment, Lordship will find each of the judgments actually false. Sorry, each of the logic in the judgment actually false. It doesn't stand. It can only stand if someone looks at the issue based on an incorrect facts. For an example, if truly the para teacher that marks had been the last marks for everyone, then learned judge is right. For an example, this 12%, if it is found to be something for the first time, any examination this has happened, then in every examination out of 100 persons, 100 of them should be academically better. But this is not. So,
All right, thank you, Mr. Jha.
well, there is a portion, this part I will not make any submission. As point number 7, only because but I'm relying on this, my lord, the judgments I have given on the point that when they are filing after 4 years, 5 years,
They ought to have made us a part.
so the necessary party I have given the judgments why it should be dismissed. I'm not reading out. The citations for my learned friends, it is AII 1963 SC 786 paragraph 9 and the 2014 16 SCC 187 paragraph 4 where ought to have been dismissed that point, and then followed also in 2022 SCC online SC 1307 14 16 SCC 187 paragraph 4 22 SCC online SC 1307. And I just added rule 12, the validity of the panel, 1 year, thereafter 6 months, then 6 months. So I was trying to look at from the perspective of the writ petitioners that yes, it is a case which has been filed during the validity of the.
On the validity of the panel, panel was not even published.
There is no requirement of publishing in
So
law, doesn't
how
require
come
it.
you take this point? There is no definition of publish.
It was on the website. It was all
But the definition.
all these documents, all these markings, they have all the calculations of 14 marks and everything, all they have obtained from the website itself.
No, your content, their contention had been there was no publication of the panel. If that,
They are absolutely right. There was no publication of the panel in a sense that the entire panel being published, but the names of the candidates with the breakup marks who have been successful, all were put on the website.
that is subsequently. That is subsequent to the writ petition. No? As called for
I will
by
answer to
court.
Mr. Dhar, my lord. Your lordship, kindly, my lord, give me permission, my lord. I'll answer to my learned senior friend, my lord.
You
So
take
far, your
note of
lordship.
that. You
Yes,
take
yes, I
note
have
of
taken.
that. We will be asking you.
On a pure point of law, lordship will not find.
Kindly come to the definition of panel.
Well,
Panel definition means a list of names of eligible and selected candidates for appointment as teacher in primary school published by the board. And Nihar Ranjan বিশ্বাস, you are good in front of me.
Yes, my lord.
This publication.
Oh,
this
that.
publication where,
What is
so the word published is not there under the rules. But that has been drawn by them. They have argued that you see these definitions, so publication is mandatory, which is publication issue was not there.
true?
Now the board's counter statement was that everything breakup and everything the single
Yeah.
judge has called for.
My contention is only this:
Yes.
no one is perfect. We learn, rectify, move on. There are certain things which cannot be rectified, and that has to go. No one is perfect. Assume
Taking the ground that you have come after 5 years.
I have taken that ground.
You have taken that.
Yes.
I am a participant.
Like nowadays, all.
I participate.
Yes.
I don't get a published panel. So what will I do?
May I say this? Then I would say that person is absolutely unintelligent. He doesn't deserve to become a teacher because.
That is because you have no answer for that.
No, not for that. Someone having, after participating, he will simply go for a hibernation. He will sleep.
Yes.
Even today, Lordship will see, we get all the orders from the Honorable High Courts.
So you mean to say it was their obligation?
I say this, may I say this?
It is not the obligation.
I say that one thing in a different angle can look something different. I say that there is a gradual improvement in the entire process. Like today, in every selection process, they are trying to be more transparent. But there was a time when there might have been some, I do say, it was not as perfect that as required to be, in a sense that every part of it has to be transparent. But this is a process, my lord, going on. Now, once informations were taken by the Honorable Court, and it was also thereafter put on the website, when that is checked up and that is found to be in order, there after 5 years, because lordships are also, when writ petitioners have come, absolutely fine. But simultaneously, the other side, kindly take an example of this. I know this is nothing to do with law. Because I got that job in 2017, because the same honorable judge also passed another order, whoever has got the job in 2017, this recruitment process, they will not be able to participate in further recruitment processes. And the board acted that. So once I got the job, I am working, I am surviving, my family is surviving, I am not able to participate in other recruitment process. 4 years have gone. Now, to look back would be too much of things required. All I'm trying to say. I don't say absolutely big no, but their requirement has to be so many things which are absent in the writ petitions or the pleadings or in the basic facts of the Honorable Single Judge.
Yes. No, that is what Mr. Mitro was saying, no? That if today they have only, if you give them the job, they will not challenge our appointment.
Because justice, my lord, what I find is justice is quite a nuanced thing. Just by termination of persons, it may look as a justice. It may look, I'm saying, because we don't live in utopia. So amount of the irregularity and corresponding whatever directions will ultimately be the very.
So for generations, persons will be taught by persons who were not competent for that thing.
Malad,
This is not a specific performance.
Malad, that formation based on fact that we are not competent has to be arrived. All I'm trying to say that the system is not perfect. I agree with that. But we deserve the system as we are. We are also not perfect. But that does not mean we are incompetent.
That is because the learned single judge reverts back the selection to the same body
That
without earmarking that what should be the parameters of aptitude.
now
Then the same mistake will go on for generations. Same mistake
yes,
will
same
go on.
mistake.
But Mr. Dhar, you cannot say, suppose you are arguing on your side, I have worked, I am in service, I will not get job. But what happens in the greater interest of justice?
Malad, choice is not between good and bad.
How the society suffers then?
Malad, choice is not between the lordship. I don't think it's not between the good and bad. Accepting the environment being such, choice between bad and lesser bad. My submission before your lordship would be lesser bad would be setting aside of the judgment and order of the honorable session. That is my submission. I don't try to say that every part of it perfect. When lordship opens up and says yes, that is there, but lordships are really not having the choices between good and bad, because system would go on. Lordship, for an example, this transparency, there can be transparency in future, but the fundamentals of saying this to be not right, those fundamentals are, my lord, mostly colored by the perception of the honorable single judge.
Thank you.
And on the validity of the panel, there are 2010 6 SCC 777, the paragraph 16, 24, 25. Now, no relief cannot be given based on Kaushik judgment, paragraph 28 also. Even today, if relief has to be given, then that 28 has to go. 2010 6 SCC 777, paragraph 16, 24, 25. And I'm not placing it. This is already, I have put in my note. And then my lord, 24.
No legal right after panel expiry. Panel was not published.
My lord, panel was approved. Publication of
Board.
by the board. And thereafter appointments were given. And then the panel has a life of 1 year.
All right.
And 6 months.
Publication was
Rule
not-
12.
Rule?
Under Rule 12,
Huh.
the panel validity is for 1 year, thereafter 6 months, then 6 months. I say that you have participated, so you know that the validity is 1 year, 6 months, then 6 months, so 2 years. So within that 2 years, you did not come.
Rule 12.
Yes, Rule 12.
An approved panel. Yes. That
Kindly see first
approval
nine.
of panel was brought by them. Approval of panel documentation was there. That they
My
will
lord,
argue.
kindly see 9. The panels after being prepared shall be accorded approval by the board and thereafter shall be sent to the respective district and school council with all necessary papers for appointment. So that happened pre February 17. And then kindly come to 12. An approved panel shall remain valid normally for 1 year from the date of approval by the board, provided that the board may extend the validity of such period panel by 6 months at a time, but the total period of such extension shall not exceed for a period of 1 year. So I take it so 1 year, and then also I take it further 1 year. So 2 years.
So the when was the approval given?
That was, I believe, before February 17.
February.
Before 7, it could.
Appointment was in.
Appointment was in February, March.
So we can take it as February.
I take it that's way. So February 17, if Lordship adds 2 years by, then my lord, I get the benefit of this judgment. 2010 6 SSC 777, and then there is a latest also 2024 SCC online SC 1189, paragraph 10 and 30.
Yes.
And there is one more also on this point. 1996 9 SCC 309.
Please, Mr. Dhar, we would request you to on the judgments,
Compilation.
like no, in 165 you said na that all right, I'm relying on these two judgments. Only the judgments which are relying upon,
Yes.
if you can point out, because your note contains
No, my lord, only. No, I have understood. Lordship may pen through here and now I can say. My lord, in 165, only one judgment called Kobita.
160.
165, page 7. Can you come my note? Lordship may put a cross on that. Page 7, Roman 4 and Roman 5.
Kavita Sharma.
Yes, Kobita and Ojoy. These two, Lordship may delete.
Others you have given?
Others, yes, all I've given.
No, all has not been.
No, sorry.
No, can you do this? The judgments, we are giving you back the judgments.
I can prepare a compilation.
Yes.
Yes. I will be happy to do that. I shall use. Oh, that's the reason.
All right, these are the judgments here. Yes, thank you.
And well, there is. Kindly give me 1 second.
30. I got it. Okay.
This is my. Well, there was a.
Chatterjee sir, the issue was.
না বাট পাবলিশ ঠিক আছে ওরা 39
Yes, what you're saying?
well there is in course of proceedings lordships ask one question that why they did not challenge an interim order. Lordship may kindly remember that one of the orders by which some
Yes,
persons
yes.
why. So I was trying to find out how to defend that part of it because no answer came from this side. Fortunately, I could get a direct page 11 of my note, paragraph 15, there is a direct judgment 2009 3 SCC 250.
Paragraph 15.
No, not para. I said
That is your.
my serial. Page 11, 15. This is 2009. That interim order not challenge is no consequence. Lordship, paragraph 28. Lordship, I have exactly quoted because I was thinking how to. And means no prayer, no relief. There are two, like everyone knows these two judgments, Kurta and this Ajay paragraph 8. And to 2003 840 মানে 8 SCC 40. মানে should I give the compilation afresh?
No,
Or
not required. If we find any judgments missing, we shall.
yes, I have all. Well, this
You have given, your junior has.
Yes.
What he has given, he knows.
Well, there are. It is so voluminous. All of us we are trying to get hold of all the points which can save us. So, and 2003 8 SCC 40 and then 2011 14 SCC 243. I'm relying on that, but I'm not reading it.
All right.
But my serial number 13. Well, they entirely relied. There is scope of reliance of RTI document. There one judgment. What has happened? What they have relied on. Firstly, it was wrong, incorrect. Secondly, they have annexed couple of documents which is their understanding based on their RTI replies. They have not annexed the RTI replies. They have only given some compilation trying to say.
So don't let them advance the argument. If required, you point
No,
it out.
only I'm saying that there is a judgment so that they can take note of that. 2021 19 SCC 396. Their High Court was not justified and had fallen into error relying on the RTI reply. In this case, our case is even better. It was not even an RTI reply, it was a compilation of RTI based on their understanding of it. Well, I shall be ending with 7th of July 2023 order, page 696.
What is this fresh selection part was set aside? What is that?
Well, I'm coming. This is Lordship is hearing this because of the order of the Honorable Supreme Court, where I only want your Lordship's attention to be drawn on two things. One, prima facie, the Honorable Supreme Court was satisfied because of we are not even party. This part. Other part is whoever is aggrieved, who challenges the order, not whoever is sailing in the same boat of the writ petition act. They can challenge it and all contentions can be taken before your Lordships. Lordship, may kindly have a look at page 703.
That has been shown to us by Mr. Bandyopadhyay.
Then I don't need to.
That the persons who are wanting to challenge them can come and say.
Phrase selection part was set aside because the Honorable Single Judge directed
that you hold the fresh
Yes,
selection.
yes.
That was that
no
is,
first 3 months time so that they can do the training.
yes.
That and then fresh selection, because now No untrained, because now the law is completely changed.
Now court said that no fresh selection should be done.
Yes,
Second part was also stayed. It
yes.
was not set aside.
No, it was
7th of July order.
yes. Lordship is right. Lordship is right. It was state.
Now, why you have said fresh selection part was set aside, this bold, in bold?
My reasoning is this, that the Honorable Supreme Court were fundamentally satisfied that these persons for 5 years who were working, they needed to be a parties.
Yes.
So therefore, whatever happened, good, bad, immaterial, they were not there. Like we are not there. Like today we are interpreting how the evidence went, but we are not there. We did not even get any chance, my lord, to examine, to cross-examine. When the Honorable Supreme Court gave us a chance for which we are surviving today, only that part. These are my, are deeply obliged.
How many?
আছে দেখুন একটু last topic.
They have not finished. They have not yet finished.
But only one more. I have one sentence. Nothing on merit. I am appearing for in this matter, but there are some visually challenged persons. So there was a request also by them. I am adopting. There is an applications filed by the visually, all are visually challenged, and they are serving for 5 years.
Give us those appeal numbers.
Yes, yes,
which
yes.
you are appealing.
Only reason that since I keep appearing for the visually challenged persons, I know them, their difficulties and every part of that. So for them, getting a job is something so big. So only adopting all the submissions I have made.
What is the number of?
Yes,
that
number is
CAN 58.
CAN 58 of 25. CAN 58.
Appeal.
Same appeal. 873.
So that CAN is for what?
CAN for addition of party.
That has been allowed.
No, that has not been allowed. It was none of the these cans have not been allowed. I make only these submissions.
Now, in any other appeal, visually handicapped are involved. In any other
In
appeal, 44
in my 635, I believe there is one person who is visually challenged. Only to draw your lordship's attentions that our world.
And we are hearing everybody.
Yes.
And will be at this stage, if visually handicapped is represented by you in this appeal also, there is
Yes,
a
yes,
candidate.
yes, yes,
It takes more.
yes. In fact, only one thing I can say from my own experience, there was a time when government never allowed any visually challenged persons to take any job. So it is our court in a public interest litigations. I remember first time when I met them, I wanted to know how you teach. You convinced me.
That is CAN 58 or 2020.
5. For them, for
অ্যাপয়েন্টমেন্ট যা হয়েছিল তার থেকে ভ্যাকেন্সি বেশি অনেক বেশি এনি কেসে সিলেকশন পুরোটা ক্যান্সেল হয়ে গেল।
well, only thing for them leaving home and to reach school, that itself something possibly we cannot think of that they have to go through. Only to I know
How many handicapped persons are there?
There are 7, but I want your lordships to take note of all.
So this 32,000 includes physically handicapped also.
Yes.
But in any case, they are protected. And why I am submitting so much? Actual vacancy of the physically handicapped. For example, it was 100 vacancy. only 30 physically handicapped persons were appointed. In any case, they are protected, madam. That's my understanding.
No, this 32,000 was 36 was changed only or mentioning
Yes,
only.
madam. Yes, madam. Why? Numbers were not clear. Even today, the numbers is not clear. 42,000 and odd. Out of them, 11,000 and odd were trained. Rest were untrained. Why I differentiate between trained and untrained? There is a reason, madam. Aptitude test, for example, ask candidate, trained candidates.
No. Suppose, do you understand the 36,000 to 32,000?
Number
What happens to those 4,000?
4,000
Today I am satisfied, I have not been sent out. Tomorrow morning I find my job has gone.
main crux of the matter was untrained, madam. Crux was trained and untrained. When it was trained and untrained, what happened, madam? There are two categories. One trained and another untrained. For example, if a trained candidate, even if he gets 0 in Viva and aptitude test, he would have been appointed. For training, the marks was 15.
No, we are not on the trained portion. We are only
Untrained portion. Yes, we are on the untrained portion.
That 15 marks goes.
15 marks goes. There are roughly 32,000 candidates in the untrained category. That was principle. I filed the application, filed a petition, and subsequent application, subsequent documents were filed in respect of those candidates. In my writ petition, my lord, I have categorically stated what are the problems, what are the issues. Subsequently, and a question came to why I didn't raise the question of aptitude test at the time of filing writ petition. Problem is that on September 2022, writ petition was filed. For the first time, one breakup of score of empanel candidate came in the light on 28 November 2022, much after filing of the writ petition. I came to know that a number has.
That is how you explained your delay.
Another thing is there, madam. The one thing, submission is being made.
We will hear.
A submission is being made. There is a regarding panel expired in 2018, but from the document filed before in this matter, appearing in the paper book 1, I can show the appointments were made in 2020, even from this particular recruitment process. That is on record. There are 11 additional panels, and out of how 11 additional panels were made, no one knows.
That is the subject matter of challenge, then anyway.
No.
And it's